It, his work focuses on, I think we all have to kind of hit our button and accept or turn off our cameras. Sorry about that. Professor Lerner's work focuses on problems at the intersection of law and technology, particularly how technology, law, and policy affect innovation and creative expression. He has written and spoken widely on copyright, privacy, and other areas of technology law. In 2016, Professor Lerner received the California Law Attorney of Law Year of the Year award for his work helping filmmakers and authors. He and his clinic have supported my team and I for the last 4 years with our making of our documentary film, The True Story of Tamar Lempicka and the Art of Survival. And I could have not made my film without quality legal. And UCI Law Clinic has provided that for me and so many other independent filmmakers. So for many independent filmmakers, we just getting our story out there and told is total fixation on overcoming all these obstacles, which can often turn into shooting first and then asking permission later. But in the heat of the creative process, it's really easy to forget that the complexities of film production and that it can become a legal minefield. There's so many people that I've known that have stuck music in their films and said, oh, I'll put it in now as temp, fall in love with it later, and I'll ask questions later. And that's just, unfortunately, not the great way to do this. And then they're heartbroken at the end. In this essential talk with attorney Jack Lerner, you'll hear how to avoid the traps and the pitfalls that filmmakers commonly encounter. So Julie, Jack's going to be doing a presentation tonight. And so you'll be handling the tech on that. We really appreciate you, Julie G. So please join me now in welcoming Professor, Attorney at Law, and my friend, Mr. Professor Jack Lerner. After your presentation, I'll follow up with questions from our audience, but we're just so happy that you're here tonight.
Thank you very much for that warm and just terrific introduction. I really appreciate it. So I came to this many years ago now, but maybe it's worth talking a little bit about how I got into this area. I was an English major.
Well, let us spotlight you really quick. I want to make sure you're pinned so we can all
Okay.
see you. There we go.
Okay, wonderful. Let me make sure my PowerPoint's in order here. Hold on just a second.
Make sure Jack is center because I'm just seeing myself here.
Yeah, he's good.
Okay. Oh, okay. Good. Just making sure.
Wonderful. I'm gonna share my PowerPoint in a few minutes, but first I wanted to just talk a little bit about how I came to this work and why it's important to me. So I started off as an English major in college, and then I went to law school, and I kind of thought that working in this business would be kind of, oh, that wouldn't be possible. I'm not a filmmaker and that kind of thing, but I was always interested in film. Always, always, always. And I ended up going to Silicon Valley and doing more tech law. And I got an offer to teach at USC. And one of my colleagues, Jennifer Urban, had to run a law clinic where students practice law under my supervision, which is what I do now. And essentially, that clinic had a few clients that were filmmaker clients, and I said, oh, that sounds really interesting. And so we began specifically working on fair use. And this is all the way back. This shows how old I am, all the way back in 2007. And at that time, for filmmakers to make fair use routinely was still kind of novel. Now it's kind of routine, but to just make fair use and not have to worry about it and be able to do it in a robust fashion was pretty was almost revolutionary. And I'll explain in today's talk why. But that ended up evolving into representing a nationwide coalition of filmmaker organizations and filmmakers in Washington in a rulemaking proceeding in the Library of Congress that was run by the Copyright Office, where you register your copyrights. And um, that and what we were able to do is essentially change the copyright law, get an exemption to the copyright law that allows filmmakers to rip from DVD, Blu-ray, streaming, or encrypted media when they're doing it for fair use purposes. In other words, for criticism and commentary, because this is a standard practice for any film editors here or technical supervisors or anything like that. That are here speaking today, you probably can say, oh yeah, that's how we get content when we need to comment on it. We actually take it from a DVD or a Blu-ray. But the issue there is that there's a special provision of copyright law that makes that illegal. So starting in 2008, together with Michael Donaldson and many students, we started going to the Copyright Office every 3 years and engaging in this 3-year-long battle it was a year-long battle, but we had to repeat it every 3 years to try and get these exemptions. And we've got one in place now. We've had exemptions in place all the way back since 2010. And in the process, I learned a ton about the filmmaking process because we had to really, really provide a huge amount of factual background as to how the filmmaking process works. And from there, my practice grew with my students in our clinic, and I moved to UCI all the way back in 2014. And since then, we've represented numerous members of women in film, and it's a real honor to be here, including Julie. Julie's like a sister to me at this point because we've worked on her film very extensively, and so one thing that I want to make sure everybody knows is please hold on to my contact information. You can find me on the web, and we really find it really meaningful to be able to work with women filmmakers, particularly independent filmmakers who don't have a lot of funding. And so almost all of our films, frankly, all of our films are right now and for the last several years have either been women-run teams or dealing with marginalized communities, and often both, right? And so that's something we look for in the few clients we can take on. We can't take on as many clients as a lot of folks, but let me I'm just going to share my slides here. Just give me a moment to get that situated. Let's see here. Let's see if I can figure out how to put it in presentation mode. Okay, I think I got it.
Great.
Okay, can everyone see? You can't always fix it in post.
Yes, we can.
Excellent. So I gave you a little bit of background about how I got into this. We have a law clinic here at UC Irvine School of Law down in Southern California. And although I did live in the Bay Area for 8 years and worked at Berkeley for part of that time and at a private firm in Silicon Valley for part of that time. And so the Bay Area is close to my heart. And our clinic, again, represents independent creators, journalists, filmmakers, artists, writers, as well as small businesses and nonprofits working on public interest issues around freedom of expression, innovation, and consumer consumer rights. So we do a lot of different things, but filmmaker services is one of our key activities that we always have on the docket. I also want to give a shout out to some incredible women lawyers who, if you haven't had them come speak, I would recommend all of these folks. I've learned a lot from them. Dale Nelson, Lisa Califf practice in Los Angeles with Donaldson Califf Perez. They're terrific. Justine Jacob, some of you may know her. She's at Focus Media Law, and she's in the East Bay. I can't remember whether it's Berkeley, Piedmont, or Oakland, but I'm pretty sure she's in the East Bay. She is brilliant and terrific. Diana Palacios in LA at Davis Wright Tremaine works with a lot of filmmakers and journalists. And finally, I want to give a shout out to my colleague Susan Seeger, who teaches here at UCI. She teaches in the clinic and runs a special project called the Press Freedom Project, where she works with journalists, exclusively journalists and media organizations on issues around freedom of the press. A lot of what she does is trying to get information from law enforcement agencies on behalf of our clients who are trying to write stories about police misconduct. She also advises filmmakers as a lawyer for Davis Wright Tremaine in Los Angeles. So if you want to be put in touch with any of these folks, please don't hesitate to give me a call. But I couldn't come to Women in Film without giving a shout out. And if any of you came to my talk back in 2021, I gave a shout out to some of these same people because they're all terrific. All right, so let's get into it. Let's talk about the legal pitfalls and the idea you can't always fix it in post is one that, it's interesting because when we tell our filmmakers, come speak with us before you've reach picture lock, right? Ideally quite a bit before, because we can help you put things in, take things out. You might sometimes be able to use things in much more robust fashion than you think. And so if you have the opportunity to work with an attorney early in the process to help you think about what what you can do and can't do, that is advisable. First thing I want to do is just give you this disclaimer. If any of you have specific questions in this presentation, I will be generalizing my answers to apply to everyone, so we can't give legal advice in this setting. So I'm happy to share a copy of the presentation if folks are interested. Okay, so I want to share a checklist for documentaries that we sometimes use when we are advising a filmmaker or when we are trying to go through everything. Now, there's not going to be a test on this, obviously, but there's a lot of things that lawyers look for, right? We're looking for a bunch of different things. Number one, do you have the rights to use what you're going to do, right? And so that is one of the most important questions, right? So if it's a narrative work, do you have the right to the story? Is the story copyrighted? Julie mentioned music, right? Did you hire someone who did a score? Do you have a contract with them, and those kinds of things, right? And so that's really key. But the other thing is avoiding getting into trouble, right? So for example, you wouldn't want to publish a sex tape. Or something that somebody had somebody's personal private financial information, if it's not newsworthy, right? If you're just some individual without it, it's not doing anything newsworthy, and you publish something deeply personal about them, like their something about their sex life or something about their financial situation, you could be liable for something called publication of private facts, right? And so it's an invasion of privacy, what we call tort, a legally recognized wrong. Another one, you want to be careful not to commit defamation, for example. What's defamation? You might have heard of libel or slander, something like that, right? So we look for both, okay, are they stepping in it in any way, or are they or are they are they using stuff they don't have the rights to? And that's the stuff that we look for earlier on. I'm going to give you a simpler slide that's a little bit easier to look at, right? And so you see the first three are actually like, are you going to step in? Are you going to get into any trouble, right? Did you slander anyone on accident? Did you portray anyone in a false light? And I'll explain what that is in a moment. Or did you, invasion of privacy? And then think about, all right, what are you doing there? One thing I want to point out is as well is that it's not just yourself, but it's the crew or other contributors. I'm going to stop sharing for a moment because I want to just fix one thing here. Okay, excellent. So, sorry about that. So,
That's fine.
go back to share. All right, back to our pre-publication review checklist. So for trademark, let me just go through these. So for copyright, obviously, if there's music that's being used that you're choosing, right, then you're going to have you're going to want to get the rights. So for example, sometimes people have said, hey, can we use this song? Now I have signed off on fair use of Rolling Stones songs, of Beatles songs. Those are the kinds of things that cost you, $50,000 to license or something like that.
Madonna,
Yes.
Madonna, you did Madonna.
Yes, I have I have signed off on the use of even Madonna, and put that in the letter as well. We won't say which film that is, but you can probably guess. Now that's because the filmmaker made fair use of that, right? So let's say you have a song by Taylor Swift and you say, okay, this individual that I'm profiling in this documentary listened to the same Taylor Swift song every morning for 3 years, and that's the only thing that kept her going. And she couldn't get out of bed without listening to this song. So we can play a snippet of that song. We might not be able to play the whole song, but enough to recognize it, enough to understand what about it was meaningful to the person, what about it which part, what the different lyrics might have meant, how we could analyze how the music was done. Another example is a very famous protest event happened in American history, in recent history, and some music happened to be playing by a very very famous music band, out of one of the windows of an apartment in the area. And so we played a bit of that song, just so people understood what it sounded like at the time. That again, that's an example of fair use. I'm going to go into fair use in detail, but I wanted to uh, give you a few examples, right? But sometimes the filmmaker will come to us and say, "Oh, well, since we used that Taylor Swift song earlier, can we use it while the credits roll?" Because it's kind of a nice punctuation mark. And there the answer would be no. Because now you're using it more for entertainment value or in a way that's separated from the direct criticism and commentary that you'd be making. Now, trademark. Film names do not have to be trademarked. And there, you can't actually get a trademark for a book name or a film name. The difference is if there is the difference is if there's merchandise associated with it, or if it's a series. So the film Superman or the comic book title Superman can't be trademarked, but all the Superman dolls and a comic book series could be trademarked, and that's the rule of thumb on trademark. However, if you show someone drinking a Coca-Cola, whether in a documentary film or a narrative piece, that can be used without permission or payment, and because it's being shown how it's actually being used, then you're not causing confusion and or diluting the trademark in any way. Now, if you showed someone like doing a bunch of drugs or committing a bunch of murders with a Coca-Cola in their hand, that might be a little bit different. But if you're just showing, kind of a natural use of the beverage Coca-Cola, you'd be fine. Right of publicity is what lawyers call uh, likeness rights, right? So if you've ever heard, oh, well, they didn't get my likeness rights, in the law, that's called right of publicity, right? And so the idea there is that you can't use somebody's image or personality for profit, essentially. It was originally restricted to advertising, and my favorite example is Barack Obama once had this one brand of windbreaker that he was wearing, and the windbreaker company was like, oh, Barack Obama's wearing our windbreaker, we're going to put that on a billboard. Well, that's a big no-no. Even though he really was wearing it, you can't put that on a billboard and use that to sell your product. As opposed to filming a news segment, Barack Obama just left these negotiations and he's wearing this windbreaker, then it would be perfectly appropriate, right? So you could also use, journalists, documentary filmmakers, even fictional filmmakers use when they're talking about real life, they don't really have to worry about likeness rights of famous people if they're doing some kind of profile of them or analysis of them. And there are cases where even newspapers could use could use the photos of all the people they interviewed in order to sell the newspaper, right? Because the idea is you're actually not trading off of the name. You're not saying, hey, this person endorses my product. You're saying the product is going to be a news story about this. And so there's for newsworthy matters and for things where there's an artistic element, and that's where the word transformative comes in. You can use you can use people's likenesses without permission or payment. So anyway, so this is kind of a broad overview. Let's get to the legal pitfalls. And I'm gonna talk about these. And a lot of these are based on experience and often pretty unpleasant experience. And so I might tell a few stories along the way. So one is, again, get the IP. Now, what does that mean? That can mean make sure that you have the story. If it's a narrative film, make sure you've got your score. If you have temp music, many people put temp music in or temp images. They might say, oh, I'm going to use this image of taken from a news program of a particular building. That's done routinely early in the process. And there's actually case law that says that's okay early in the process. But if you then put that out there into the world, you either have to get permission or decide that make a determination that it's fair use. So getting the IP is important, right? And that and I make a distinction between that and getting releases, right? So if you do a profile on someone and everything in there is true, you don't necessarily need a release. If you're not committing libel or slander, if you're not publicizing deeply private things about them that aren't newsworthy, right? So if you have, for example, a famous politician and you say this person actually had all kinds of secrets, that's probably newsworthy and probably fine. If you're profiling somebody who's not otherwise newsworthy, then it gets more dicey. So why do people get releases? Because then you don't have to worry about it, right? Probably more than one filmmaker in this webinar who's in this meeting tonight has a story about a subject that decided, oh, I'm actually not very happy about your film anymore. And so I'm gonna, make a stink about it. I'm gonna be upset about it or whatever. And so getting a release ahead of time is really important there, because then you don't have to worry about it, right? And there's lots of examples of that. Did anybody see? Just raise your hand. I can see that everybody here on the grid, or most of you. You know, did anyone seen Queen of Versailles? So no, the one about the I think wasn't it called Queen of Versailles? It was about a timeshare multi-millionaire, and he was building the world's largest mansion. It was going to be like 100,000 square feet, and
Yeah.
they
Yeah.
didn't look very good in the film, and they sued. Well, they had signed a release saying, I allow you to use all this, and so they quickly lost in court. Now, one tip on getting a release is sometimes it's always a good idea, if you're filming it, if you're already filming, and they haven't signed the release, film the signing of the release. And we had a situation like that where one of our filmmakers actually had the subject on tape signing the release and actually said, "This is my distinctive signature. I invented the signature in high school." So they really couldn't dispute that they had signed that release. Because later someone started whispering in their ear, and they got upset with our client and made a stink. But there was nothing they could do in that situation. We ended up actually executing a new release that had a lot more detail to it, but the film is moving forward. And So getting the releases now, you interview subjects, it's always good to get releases as well. But if you're filming a parade, you don't need a release from everyone in the parade, or something like that. And so releases are more insurance than strictly necessary as a matter of law. Now, if you look at number 7, insurance, right? If you don't have releases and there's something controversial about the film, you may need to um, you may need to uh, get a letter from a lawyer saying, "Oh, okay, I've reviewed this film and there's no claims in this film. There's no defamation, and so even though they don't have a release, it's okay," right? So you want to avoid that, because you have to find a lawyer to write that letter. And we've written those letters in the past in the clinic. By the way, I want to welcome some of my colleagues in the clinic who are here tonight. I see Ivana Villanueva, Daniel Mina, Ari St. John. So thank you for joining us. These students are working on our filmmaker projects this semester, and so we've got some law students here. Okay, so that's some thoughts on getting releases. Understanding fair use. We're going to talk. I've got a bunch of slides on fair use, but if you understand how fair use is made, and kind of the basic contours, you can save a lot of time and probably a lot of money in legal fees by uh, by kind of getting ahead of things, in terms of, okay, I'm pretty sure I can make fair use of this because I'm commenting on it, right? So a great example would be, oh, I'm doing a film about Picasso, and I'm going to have this art critic dissect Picasso's most famous work and explain various aspects of it. And we're going to highlight the top right corner, and we're going to look at the way his signature evolved, and we're going to look at the angles and the use of light. A lot of that would be fair use, and so understanding that's fair use, as opposed to, well, we decided to stage an interview and put a bunch of copyrighted Picasso pictures behind the person as decoration. That probably would not be fair use. I see a question, and I want to ask our moderators, should we, do you want me to, I'm happy to answer questions as we go.
I think we should just wait to the end, if that's okay. That way we stay kind of focused.
Okay, no
Okay.
problem, no problem. Okay, now here's one. This is a pitfall that is pretty important. We had a filmmaker who had worked with their crew for years, and one of the camera persons was really interested in the subject matter and started posting some of the raw footage on social media saying, today I taped the most amazing thing ever, right? As a filmmaker, how does that make you feel? Oh no, we've got a big problem here, right? Oh my gosh. And so stop, red flag, red flag, red flag, right? So in copyright, um, copyright law gives filmmakers or film production companies a hugely valuable, critically important tool, and that's called the work made for hire doctrine. So work made for hire means that you as the filmmaker or you as the production company are considered the author and own that material even though somebody else filmed it. How does that work? There's two ways. Number one, you are their employer, right? So you provide the camera, you pay their payroll, you know, they're going to have another task for you after this production is done. And you know, it's kind of like essentially the Supreme Court said, you know, if it looks like a duck and it walks like a duck and it quacks like a duck, it's a duck, except they said that with employment, right? So they said, you know, who pays their payroll taxes, right? You know, and all that kind of stuff. If they're not your employee, which is of course the case for most independent filmmakers, they're just independent contractors. Like, you know, who has ever said like, I need an editor, I need a camera person for this production for the next 3 weeks or whatever, then you have them sign an agreement that says this is a work made for hire. In most parts of the country, including the Ninth Circuit, which is the entire West Coast, you can't have it be a work made for hire unless the agreement is signed before filming starts or before the editing starts or whatever creative activity it is, right? So you might not, now if you have a graphic designer who says, let's say you want to, you know, option a story, that would not be a work made for hire, but you know, you get the rights ahead of time. But when it comes to your crew, before they start shooting film, you want it to be put in writing. This is a work made for hire, meaning I own the rights outright and we're done, right? And that's really, really important so that they don't start posting on social media and then saying, oh, well, I shot this, so I have the copyright, so I have to license it for you. And you say, yeah, well, I paid you to shoot it. And you can say, well, right, but it wasn't a work made for hire, so you still have to license that for me, and it's a big hassle. So making sure your crew is under contract is something that might seem elementary, but it sometimes it isn't unless you've thought of it ahead of time. And so obviously it's not just making sure your crew is under contract, but if you get a logo for your film or the LLC, you know, make sure that whatever paperwork you sign with that graphic designer says, you know, you have all rights to use this, or they're assigning you the rights to that logo, right? And obviously, you know, lawyers like us can help you do that. Keep your content secure. Here's another war story. Uh, we had a filmmaker who was working with kind of a shady sales agent. And the sales agent started talking to the editor, who was a third party, you know, who they had just been working with, and said, "Oh, we're all in this together. We're all working on this together. So would you share the raw footage with me?" You know, and so the editor shared the hard drive, and the sales agent recut the film according to the sales agent's creative uh, creative perspective, or however they wanted to do it, and not the way our filmmaker wanted to do it. And our filmmaker had to fight like crazy to get their vision. In this case, it was her vision to the screen. So make sure that everybody's clear that the footage can't be shared with anyone else, and get it in writing. And some filmmakers even say, okay, well, I'm coming back to pick up the hard drive, you know, on Monday. Has anybody ever had to deal with this? Julie. Okay. Yes. And because I saw you shaking your head on the Zoom.
Yeah, no, it's not fun when you've had somebody take from you, and it's
Yeah.
Very
It can
violent.
be, I mean, it can be soul crushing. It can be,
Violating.
yeah, it's really violating. All right. So the sixth pitfall to avoid during film production, and this goes back to what I was talking about with the Digital Millennium Copyright Act. So most of you have heard of the DMCA in the terms of like YouTube. You know, I got a DMCA takedown, or my kid got a DMCA takedown for their YouTube video or whatever. But there's another aspect of the DMCA. So in 1998, Congress said, okay, we'll give a safe harbor to YouTube and all that stuff. But Congress also said, we are going to give special legal protection. So we're going to write a new provision of the copyright law that's going to go at the end. And that is going to give special legal protection to certain technologies that protect technological protection measures. So encryption. In other words, Congress made it illegal to break encryption when that encryption was protecting copyrighted content. So that means that if you rip a DVD, even if you're ripping it because it's a compilation that has one of your films on it, as well as maybe somebody else's film, you can still be breaking the law, even though you have every right to that work. Or what if you want to make fair use of that work? You have every right to use the work. You'd never get sued for it. You'd get insured for it. It'd go to Sundance. It'd get in the theaters. Everything would be fine. It's still illegal to rip from the DVD, but we were able to go to the Library of Congress and get an exemption. So if you're ripping, only take what you need and keep that secure, right? I've never heard of an issue where somebody used the exemption that allows documentary and historical or biographical filmmakers to rip from DVD, Blu-ray, and streaming media for fair use purposes. I've never heard of that exemption leading to any kind of piracy or copyright infringement. And we've been dealing with the issue since 2008. That being said, keep that content secure, right? And only take what you need for the project. And if there are viable alternatives that don't involve breaking encryption, use them. However, generally there aren't. We don't know of any. And when we've talked to technical experts, they've said essentially, if you want your content to be broadcast, or to make it to Netflix, or to make it to theatrical, it has to be in 4K. It has to, and that can't be up-resed 4K unless it's archival material or something like that. And so broadcasters and distributors will reject it if you don't rip. So that's why most filmmakers do that when they need to make fair use of copyrighted content. I'll talk about that a little bit. Here's something to think about too. Most filmmakers don't get errors and omission insurance until the last moment they absolutely have to, in our experience. However, we advise get your insurance in order earlier if you can, right? So there's two ways to think of the insurance that's available to filmmakers that filmmakers need to get by the time they get to a distribution level. One is media liability insurance, right? So if you've gotten releases from everyone, uh, if you've got all your content in order, you basically fill out a form and you give it to an insurance. The insurance broker will provide the form, and then they will then come back to you with quotes, and here's a premium that you'd pay, and here's the coverage that you'd get. Most coverage, it lasts for 3 years, and it essentially handles any suit. So if someone comes at you for copyright infringement, someone comes at you for defamation, or if you forgot to get a release, and they say you use my likeness or use my script, and the release that you got was wrong, or the person you got it from didn't actually own the rights, you can get insurance for that. Sometimes it's called media liability insurance, sometimes it's called errors and omissions insurance, but it's the same policy, right? And the policies are actually, you don't have to be a lawyer to be able to read and understand the policy. They're written in pretty clear English. The deductibles are I've seen anywhere from $1,500 to $5,000 or more dollars. And they last for a period of about usually 3 years. And the deductibles are between $10,000 and $25,000. So this isn't car insurance, but it's also if you have a budget of, almost any film budget should account for an insurance premium. Now, what is the advantage of getting it earlier? One of the issues is if you get a demand letter, right, that says, hey, you're using my content and you don't have permission, and stop using it. Do you think an insurance company is going to be excited to insure that production? The answer is probably no. They're going to say, wait, why would I insure this when there's somebody waiting in the wings to sue you if you use this stuff? So I'm going to step away. But if you have insurance early on in the production, then you have to worry about that. Now, usually that's very rare that happens. I've only seen that happen once. Uh, so that is pretty rare. But having that insurance, because you can also get insurance for there's also production insurance, which is like if somebody slips and falls on your set, or the catering is they get food poisoning from the catering, things like that. So there's production insurance, but I'm referring more to media liability insurance. And if you've got the budget and it's in your budget, getting insured earlier is good. And another thing that you can opt for with insurance is, even if you've already made the film, you've reached feature lock, Sundance or Tribeca are like, okay, we're gonna screen this film, this is great. Then you get insurance. You can actually get it insured retroactively to the inception of the production. So if somebody comes at you and says, well, 2 years ago you copied this off of my website and you committed copyright infringement, it would be covered. So getting insurance in order early is great, and a lot of times people do wait until the very last minute, and we don't advise that. Here's something we've seen once or twice too, and these are a little bit more in the weeds, but they're pitfalls, right? Maybe you consider them more like potholes than pitfalls, but here's something we saw one time that was a little bit mind-boggling. So we had a wonderful film about a beloved TV character that was there. First, they were in a novel, this character, and then the character was in a bunch of movies and even a famous TV show. During the 50s and 60s. And it's actually based on a real person who lived here in California. And so this lovely little film, was about this person and her relationship to this TV and film franchise that grew up around her own story. So they didn't have any problem with they didn't have any problem with the individual they were profiling. She was great. But what they did have a problem with was they wanted to get permission to use from one of the big studios to use images from all these movies. And the studio said, it's going to cost you $50,000. And the whole budget for this film was less than $50,000, right? This is a person who's a professional editor, and our client was basically doing the whole film, which is a wonderful little film, based on credit cards and favors, and it's like his friend was going to help with the editing and this and that. So he had no way of ever raising $50,000. And so he kept going back and saying, please, please, please. And they said, no, we're not going to, just stop calling us. Like, we're not going to do it. So he came to the clinic. And we said, well, you can make fair use. Why don't we help you make fair use? We made robust fair use because there were parallels. You could say, oh, I'm going to talk about now this particular scene. We interview the actor who was acting in the scene, and he said, oh my God, it was actually 40 degrees and it was supposed to, it was really cold, but I had to have shorts on, and so now you can show the scene, right? And that would be fair use. So we made fair use very responsibly, very robustly, and then we got it insured. And about a week after we got it insured, my filmmaker called me and he said, we did get a festival license from the studio. Should we let the insurance company know about that? And we said, yes, we should, and we should look at what it said. Well, here was a line in the license, and this is in every license that you would get from a studio. I agree not to use the footage for any other purpose other than what's the four corners of this license. Well, the license they got cost $100. It was like, can I just show this at this little local film festival in my city? And the studio said, sure, it's $100 license. You can show it this one time at the festival. So that's what they did. So the insurance company looked at that and said, you've now contractually agreed not to use it for any other purpose. So we can't insure this. And they actually wrote us a check, gave the premium back. And I actually have a screenshot of the license. Let me see if I can find it here. A lot of slides. I may not get through all of them, but that's okay. I think my PowerPoint just froze up. Oh dear. PowerPoint crashed. Oh, that's not fun.
Okay, that's just technology. Why
All
don't
right.
we, why don't
Oh,
we, you
go
go,
on.
go ahead and get your PowerPoint back on. You've got time.
Okay. Yeah, how are we doing on time?
We have a good, 10, 15 minutes before we're gonna have some questions.
Okay. Okay, great. So
You're totally fine. You're totally
good,
fine.
good, good. Yeah. Um
I'll tell a story. I'll tell a story. So someone that was working on my set one time decided that they were going to take the scenes that they had shot because he thought he could use them for his reel. And I couldn't understand during break why my computer wouldn't work. And my computer was really slow. I was like, why is my computer so? Because he was downloading footage and putting them into a folder on my laptop.
mm,
And we had no idea that this was happening, what was going on, until later on I found the folder that evening. And
mm,
it was all his stuff on he was the B
mm-hmm,
camera.
mm-hmm,
So I confronted him on it. And
mm-hmm.
he admitted that he had done it and he thought it wasn't a big deal. Um, and we hit heads and he ended up giving me back the folder. I'm not sure if he copied it or not, but I let him know that if he used it, and we did have a contract that I wouldn't be happy about it.
Yeah.
So, but I do know what that feels like to be on a set and have someone literally right there just
Yeah.
from you.
Now, it's funny because there's actually a case, and I have a slide about this case where somebody did use a reel. Where is it? This case here. Uh, so the actress used a reel from the film Girl Lost, and the actress is this individual here, and the filmmaker did not like that she had used a clip for acting reel, and the court said that is fair use. Right, because you're using the clip, but obviously what this cameraman, you said he, so this cameraman should have done is talk to you about it, obviously,
Yes.
or take from the final product and
Yes.
use a tiny snippet for his reel from the
Exactly.
final product, right? But the raw footage, obviously, that's a no-no and very much a violation. So going back to the festival license, just really quickly, uh, something like this term of use. And I agree the footage will be used solely for this purpose. And so this is the only thing. There are also sometimes there are non-derogation clauses you want to be careful to, no derogatory references towards the series or the film, or there's one that's so broad it's like you can't even be critical of the entertainment industry in the way that you use this clip you're licensing from us. So those are a couple of examples. I'm just going to go back to my let's see here. Just going to go back to my I have a lot of slides that we're not going to get to, but that's okay. It looks like it didn't say my list didn't get saved somehow, but let's see. The other a couple of other things that we run into that are troublesome. and I'll just talk about them quickly, and then I can either kind of get more into the nuts and bolts of how to make fair use, or I can just take questions. There's a lot of content on the web that's sort of advertised as free, you know. So there's this website called like Pixel. There's a bunch of websites, or Flickr is another example where there's a lot of material that's licensed using Creative Commons licenses, or that just say this is free to use, this is all free to use. And unfortunately, if you look at the fine print, they basically say, uh, oh yeah, we're saying you can use this for anything, but we're also not giving you any representations and not warrantying that this is actually licensed content, that you're allowed to use this content. And so, you know, people upload copyrighted content they don't have the rights to Flickr, and then they make that available using their Creative Commons license. And Creative Commons licenses, can folks, does anybody know what a Creative Commons license is, or does everybody know what a Creative Commons license is? No. Okay.
Please explain.
So uh, it's a really interesting idea. So the idea is you've heard of, you know, copyright 2024, Disney Pictures, all rights reserved, right? Everyone's heard the term all rights reserved. What if you're an amateur photographer and you just want people to see your photography and be able to use it? You know, I have a friend who's a bird watcher. He has thousands of photos of birds, and, you know, if he wants to put those up and just make them available to the world, how would he do that? Right? If he just put them up, you wouldn't have any, you'd have to go find him and get his permission to use the work. Otherwise, he could come after you at any time. So about 20 years ago, a little more than 20 years ago, a nonprofit based in San Francisco started called Creative Commons. And they said, you know what? I don't want to release my content to the world with all rights reserved. I want to release it some rights reserved. So you can use it, but you can't. You have to give me credit, or you can use it, but only for non-commercial purposes. Or you can use it, but you can't like remix it or modify it. You have to use it, you know, in its original state. And other minor restrictions like that. So many blogs have Creative Commons licensed. All of Wikipedia uses Creative Commons licenses. And so Wikipedia is free to use for anyone because of these licenses. So that's great for filmmakers. If you go onto Flickr, you can find millions of photos that are Creative Commons licensed. Most of these are legitimately, you know, the photographer who uploaded it to Flickr used the license. You can do Google image searches for Creative Commons licensed content, and you'll get millions of results. And many, if not most of them, are legitimately licensed. But every once in a while, you see something and you're like, this was obviously a professional photograph pulled from a magazine. And this, you know, this user, you know, Joe 6475D or whatever is not the actual photographer. And then you have to be careful. And some of these sites that say free content, and I think there's one called like Pixel, pixel.com is a good example. They say it's free, but if you look at it, it's kind of clear some of these not were not procured by Pixel, and they didn't get the rights and then license you. You know, Pond 5 is an example where it is pretty much safe to use, right? And if you were working with us, we'd probably kind of look under the hood at that particular asset and look at the license language of Pond 5. But Pond 5, stock footage houses, if you license those, what's another example? Obviously Getty and those, if you license those, then you don't have to worry about someone coming after you. Now, Getty Images tries to charge for a lot of works that are in the public domain, right? And so you can find footage of the Russian Revolution that's actually in the public domain, even though Getty has a license to it. But if you license from a stock footage house, you're agreeing with them by contract to pay them for that use. So if you get it from the stock footage house, you have to pay for it. If you get it from somewhere else and it's in the public domain or you're making fair use, then you're fine. I want to conclude before I take questions with just talking a little bit about how we think about fair use, right? And I'm gonna show you a couple of different slides here. Let's see here. I'm going to show you a couple of different slides here. So all the way back in 2005, uh, all the way back in 2005, a statement was released called the Documentary Filmmaker Statement of Best Practices and Fair Use. It's a 12-page statement. You don't have to be a lawyer to read it. And this was developed by the major documentary filmmaker organizations of that time. IDA, National Alliance for Media Arts and Culture, Women in Film and Video, which is a Washington, D.C. organization. And they all got in a room and said, what do we think is appropriate? And there were two or three lawyers in the room who were copyright experts who then basically said this is, and they had an advisory board, and they basically said, yes, these are track with the case law. And this is still a very useful tool to this day. And so they basically said there are 4 practices, and they all and some of them say, you know, well, you should give credit or something like that. But one is social or political or cultural critique, right? So what is critique? Has anyone seen the film Killing Us Softly about the use of sexist imagery and violent imagery in commercials? I think it's mostly about the image of women in commercials. And there they show countless commercials, virtually wall to wall fair use. Great example of social, political, or cultural critique to illustrate an argument or point, right? That might be another example where you don't say this commercial is sexist or this commercial is a problem. Instead, you say this commercial, many commercials do this, and here's an example, right? Incidental use is really important in documentary filmmaking, right? So if let's say it's, I'm going to film my subject walking down the street, and there's going to be copyrighted signage there. There's going to be music coming out of the bodega or coming out of the Forever 21 store they're walking past. And you don't have to blur out or censor reality in order to portray reality. You know, my favorite example is, let's say I'm doing an interview of the dorms here at University of California, Irvine, at UC Irvine, and somebody has a Beyonce poster or up on the wall behind them in the dorm. I don't need to blur that out or change that as long as I didn't stage that setting, right? So if I put the poster up, that could be an issue. But if I'm just going into that person's natural setting and there's a bunch of copyrighted content, then that's what we consider incidental use. And there is case law supporting that, but not if you stage it. And then finally, in a historical sequence. So let's say I'm talking about the civil rights movement, and I'm saying, Bob Dylan's music was really important in the civil rights to the early civil rights movement, or the early 60s part of the civil rights movement. And so I show some images of his music being played, or I show images of that time to show kind of what was going on with Bob Dylan, when that music first became associated with that movement. And showing those images in a historical sequence would be an example of fair use. So we look at the statement of best practices in fair use, and we also look at kind of a 3-step test, where you're really kind of just asking these 3 questions, right? Are you using it to illustrate or support a point that you're trying to make, right? It's really simple, Am I saying, oh, I use this clip of Sunset Boulevard because it was really beautiful and it was actually very funny? Or am I using Sunset Boulevard to say that the use of, that the most famous scene of a woman going down a staircase in history was from Sunset Boulevard. And now I'm going to show you that, right? I'm using it to demonstrate my point. I'm not using it because it's cool, or because it's funny, or because it makes my film more entertaining, even though a lot of fair use is very entertaining. Are you using only what's reasonably appropriate, right? So are you using like not just the scene, the famous scene of Gloria Swanson going down the staircase in Sunset Boulevard, uh, but the 5 minutes before and the 5 minutes after, right? That probably would not be appropriate, right? And just a few seconds of her going down the staircase, or maybe a portion of that scene, or somewhere between a portion and a majority of that scene, would probably be appropriate, depending on how it was being done. And then finally, the third one, sometimes I call this the sleepy judge rule, right? Like, is that point clear, right? And if it's not clear, you might have an issue. And so remember, I gave an example earlier where I said, okay, well, this individual that I'm profiling, you know, she listened to a Taylor Swift song every morning, and that's what got her out of bed. And that's what kept her going. And so I'm going to show the Taylor Swift song. So that would be something where if a filmmaker came to us and asked us if they could do that, we'd say, absolutely, you can, you know, and we'll look at how much you're using, and we'll look at the way it's being used, but that general concept is going to be okay. But if the filmmaker came to us and the film just happened to be playing Taylor Swift, the same Taylor Swift song throughout the film, we might say, we don't see the connection here. Why is this being used? And then the filmmaker says, our client says, oh, it's because this was so important to our subject. This is what got her up in the morning, and blah, blah, blah. Then we'd say, okay, you have to make that clear, right? That connection has to be clear. And this is one of the big takeaways about fair use, and one of the things that's hard about fair use, which is you don't necessarily want it to be clear. That might actually constrain your artistic vision. And that's a reality of making fair use, that it is not as it's not the same as if you have the rights, because sometimes you might want to luxuriate in that song, right? A great example is, has anyone seen Jazz by Ken Burns? It's like 25 years old now. It's a great documentary, but you know what bothers me? He just doesn't let the music play. Like, he only plays little tiny snippets. And you might want to luxuriate in the music. And I've always thought to myself, I know he had the rights, right? That guy has the biggest budget of any documentarian in the world. I know he had the rights to those songs, but that he kind of reminds me of someone making fair use. They might not be able to use that much of the song. And so sometimes making fair use can be an unfortunate kind of a constraint. So you can take lots of films and put them on this spectrum from, oh, this is easy fair. These are all names of different films. These are easy fair use. I just want to go to one. Yeah. So we use these two rubrics. And the right is from a short film that I made with a filmmaker named Kirby Ferguson called Everything is he made a series called Everything is a Remix. And then we made a little sort of bonus film that's only 3 minutes long, and it's a design for YouTubers, but it totally applies for documentary filmmakers too. You know, how are you making fair use? So with that, I'll open it up for folks to ask questions, and we'll go from there.
Great. Thank you so much, Jack. That was amazing as always. I'm sure our audience has questions, so let's open it up. And if you have a question, please click on the reaction button at the bottom of your Zoom screen, and then click on the raise hand emoji. And Nicole, maybe if you're okay with it, we can look at whose name it is, and then you'll just unmute yourself and you'll ask the question. And I can also do it, Nicole, it's fine. So let's see, or if anybody has somebody that you knows first, because you guys have been kind of following along the chat. Jack, if you would mind putting your wonderful presentation that you offered us so generously into the chat so that our guests can take it, the link to it, that would be fantastic.
Okay. I don't have a
Awesome.
link to it because it's just on my desktop, but I can
We can do it later. It's up to you. I just
okay.
want the fact that you're offering that, we all would love to have that. So we'll figure that out.
Bet.
So does anybody have a question? I'm not seeing a hand up quite yet.
There's
Um,
one.
Go for it. Go ahead and unmute yourself. Amy's in.
Hi there, and sorry for not opening my camera. I'm not in a good location, but thanks. This was an amazing and super valuable
Oh,
presentation. I'm
good. Wonderful.
so thrilled and looking forward to watching it again. And I recognize a lot of issues that have come up for me and my students. That said, I was wondering if you could just tell us a little bit about that sign that I've seen sometimes in a public place that people will put up that says, film is being made here. If you happen to be caught on camera, this is your consent to be in the film.
Yeah, I think that's so first of all, there's nothing, if you're not using somebody's likeness for commercial purposes, you know, you're not gonna use it to sell a product or you know, use it somehow, turn it into uh something that there's no sort of subject matter connection to it. If they're in public, you have a right to film them. So if someone has a sign up on out like outside their store that says that, that's superfluous anyway. The ID, you know, if someone consents to being filmed, that, you know, just gives the extra little bit of protection to the filmmaker. And it's always good to have people on notice so that they can say, all right, you know what, I'm not into this, I'm going to leave, or something like that, right? So it's an ethical thing to do, in my view, to make sure people are on notice. But it's not necessarily necessary, because again, the law says, you know, I'm filming an art gallery opening and people are going into the gallery, and they're really there. So that's probably, there's nothing that could open you up to liability about that. But one of the questions that's on the insurance questionnaire is, do you have permission from everybody that you filmed? And so insurance companies will ask that. And if you can say yes, that's helpful, right? If not, you can say, well, there were some public or semi-public environments where people were filmed, you know, and often the underwriters who look at this and who understand it pretty well will say, oh, that's fine. Or they might say, we're going to need, if it's something where you've got something that's pretty graphic or stark or something like that, they might say, we want a letter from a lawyer that says this doesn't violate anybody's rights to privacy, or doesn't constitute libel or slander, something like that. And so yeah, that's my answer on that. It's probably a good idea to do as a filmmaker, but you know, if you don't do it, it's not gonna mean you can't use the footage.
Gotcha. And I was thinking in terms of, let's say, a low budget indie feature or a short film as opposed to documentary, but great. Thank you. Thanks so much.
Sure. A
Neil.
low budget indie feature would have the same analysis.
Okay. Hi. Sorry, my connection's kind of slow. My question is around SAG. I don't know if you've dealt with SAG very much, but I shot a short film last year that was a micro budget SAG feature, and it took me quite a while to figure out the right thing to do. And I got some vague answers from the SAG office about how to pay actors and what kind of agreements are needed. And the end result was basically that this micro budget agreement allows me to negotiate any of the terms with the actors. So we ended up not really doing workman's comp or anything like that. And I'm just wondering if that was the right thing to do or not.
Well, so we have not dealt with the guilds, because you know, the guilds have agreements with major studios and major producers, and everybody else doesn't have those obligations. So the contract that people were striking over was with members of the producers alliance. It was not with just all filmmakers everywhere. So so a SAG actor, I think, my understanding is free to work with anybody who is not part of the producers alliance and not subject to the contract. If they work together, then they need to, if they're working with somebody from I think it's I forgot the acronym, but the general gist of it is if they're working with the let's say well, Margot Robbie, she's been in the news, and I'm still a little bit salty about the situation there. But Margot Robbie, you know, as far as I know, she's free to work with, you know, if I decide to make a film, she's free to work with me, and I don't have to worry about SAG because I'm not a member of the producers organization. And so I think in terms of your agreement, whatever that says, is what would govern. And I'd want to look at the micro budget agreement, but that sometimes frees up SAG actors who are worried about, okay, am I going to be going outside my contract? Does that answer your question?
Yeah, I mean, from what I understood, if an actor is in SAG, then they do have to take into account whoever they're working with. It doesn't, any kind of indie producer could
Right.
also,
Okay. Yeah.
would also have to buy the agreement, but the micro budget agreement is kind of like, oh, hey, everything's up for negotiation. So, yeah.
Yeah, so in that case, that's kind of like, remember I mentioned the festival license, right? So this is a case where our client wanted to use like a ton of clips from various properties owned by this big studio, and they said, here's this is just like a small thing, so we're going to give you kind of a side contract that's not really licensing you to do all the other stuff. By the way, there was a happy ending to that story about the guy who got the festival license and couldn't get insurance, which was we took the film to the studio. And I happen to know through professional societies, one of the vice presidents at this studio. And so I went over to campus, sent the DVD over ahead of time. This is in the days of the DVD, and you know, she looked at it and she said, "Okay, well, we agree this is fair use, so we'll give you a license that doesn't require you to pay us you have until you have started to make money," which he never did. So he never had to pay for that property, pay for that license. But it did have a happy ending. The film got distribution around the world. It's a neat little film. And since I told you inside information, I can't tell you what the film is. But going back to your point, yeah, that's that. I think you're right, actually, Neil. That's how filmmakers work with SAG actors if they're not part of the Producers Alliance.
Oh, thank you.
Next is Diane.
Hi, I have a question about likeness rights and the impact of AI on this now. You know, with AI coming in, we're bombarded with filmmaking community anyway, ways to use AI and as a tool and these things. And I was just wondering if how you are, or do you have to kind of rethink certain aspects of likeness rights with AI becoming part of the equation here?
Yeah, so it's interesting. So let's talk about AI for a few minutes. So the way American law works right now, and this might change, um, is that whatever OpenAI or DALL-E or whatever Stable Diffusion or any of these, what we call generative AI services create is essentially, for copyright purposes, OpenAI, the company, can't claim copyright over those items. So whatever those things generate, because they're generated by a machine, they're in the public domain. They're created by a machine, no copyright. It's wild, right? So you go on there and say, give me a picture of a monkey, typing on a typewriter, and it generates a picture, then that is in the public domain. Here's the big exception. If you can point to some other work that is what a court would say is substantially similar. So if it happens to, you know, you've seen, I don't know, a famous painting would be, what's a famous painting that's still under copyright?
Botticelli's Venus.
Well, that's in the public domain.
Oh, yes, you're
So that
right,
wouldn't
duh.
count. That wouldn't
Yes, you're
count.
right.
Right.
Um,
Picasso. Almost all of
Picasso.
Picasso's works are still under copyright. So let's say you say, give me a Picasso looking painting of a chicken, and it pulls up something that's identical to a Picasso. That would still be, Picasso's heirs could come after you and say, hey, you did this. So if you're going to use an image from an AI service, maybe do like a reverse image search if it's a static image. And if there's not an ability to do that with video, then, it is what it is. Now, when it comes to likeness rights, so let's say you say, give me a picture of Margot Robbie driving a Mercedes in 1960, or give me a short film of that, and that's what it gives you. That image would not be copyrightable. It would actually be public domain unless it was identical to some film. But since Margot Robbie wasn't making films in the 1960s, you're probably good on that. But you still would have to deal with her likeness rights. Okay, so that analysis doesn't change. So now we have the question is there something artistic about it? Right? Is there something newsworthy about it? In which case you're okay. And when I say something artistic, a great example, I actually have a slide for this I'm going to pull up real quick, because it's a really great case, and we actually wrote a friend of the court brief, which totally tracked the California Court of Appeals viewpoint. So there was about 7 years ago, there was this film it's a series actually called Feud, Betty and Joan. Jessica Lange played Joan Crawford. Susan Sarandon played Betty Davis. And it was based on, and one of the characters was Olivia de Havilland, who was known as like a very classy actress, and just the epitome of class. And in the film, she's played by Catherine Zeta-Jones. She's like the Greek chorus, and she's talking about this feud. And she said, I think she was referring to Joan Crawford as a bitch, and Olivia de Havilland sued because she said, I would never say that. I referred to her as Dragon Lady, and I am very upset about this, and they should have compensated me for this, and then I would have been fine with it. And the trial court said, yeah, they should have compensated her. And the movie industry and all the independent filmmakers and all the documentary filmmakers said, what? No, you could never make a movie if you did it that way, right? You could never make a movie about that ever touched on real people if this were allowed to stand. And so this whole series, which was a 10-episode series, speculating on the relationship between Betty Davis and Joan Crawford, the court said that does not violate the right of publicity or likeness rights of Olivia de Havilland or of Joan Crawford or Betty Davis, right? And so speculative fiction, as long as you're not making factual assertions that they actually said this, has a lot of leeway, right? Another example, again, if I show Taylor Swift walking down the street and I'm filming her for a news program or something like that, that would be fair use, right? Now, so if I want to use AI to create a speculative short film about what Taylor Swift's life on tour is like, there's a good chance that would be okay, but you'd want to get someone like us involved to help you figure that out, because that's going to need a lawyer. So that's my long answer to kind of a challenging question. Obviously, AI is new, but the big takeaway is, if you're using someone's likeness, there needs to be some kind of transformative, nature to it. It's got to have an artistic point, or you're doing some kind of criticism or commentary around that person, or what you're doing is newsworthy, or you can't use their likeness.
Okay, thank you very much.
Next is Kelly Kraus. Sorry, I don't have my glasses on. Go for it, Kelly.
No, Kraus is perfect. Thank you.
Good, even without my glasses. Got it. Okay.
Hi, everybody. Firstly, Jack, thank you so much for being here tonight. And thank you to Julie and the Women in Film team for organizing this wonderful event. Jack, I apologize in advance because my question is quite broad and nebulous. I'm hoping you can maybe still help out. I am in new territory developing a feature-length narrative anthology. And I'm very fortunate to have a co-EP who has produced 2 anthology films, and I very much trust their knowledge and expertise. However, I am still wondering if there are any legal pitfalls with regards to anthologies that we should be wary of or keep an eye out for. Again, I know that's very broad.
Well, when you say anthology, so you're talking about multiple filmmakers doing, you know, and you'd have kind of a collection of films that would be, you know, like, would it be like Small Axe? Did anyone see Small Axe, which was 5 films that Steve McQueen, the director Steve McQueen, not the actor, did for Amazon? And it was like 5 feature-length films that they all kind of released in a bundle. Is that what you're essentially saying?
No, so this would probably be it's within the same genre as well. So it's a horror anthology. So it would be in the vein of something like VHS, where each film is, you know, roughly 10 to 20 minutes. So that the runtime is probably akin to somewhere between 100 and 120 minutes total.
Yeah, I mean, if you're going to have a bunch of different directors and crew for each of them, you know, then you're going to want to make sure that you have the rights from all the directors and crew. Either you know, the right licensing that you need to do what you need to do with the film, or that it's a work made for hire. As a work made for hire, obviously it has to happen beforehand, and it's more likely that you're going to be licensing the production as a whole. But if you're doing that, then, you know, you want to, all of those licenses will have clauses that that kind of are the teeth of the license. So reps and warranties, right? I have the right to this, and that's my representation to you. I have all the rights. There's no camera person who's going to be uploading the footage and claiming that he owns a copyright, and so on. And indemnification. Indemnification is, and if somebody does come after me because of your footage, you are going to pay my legal fees and the damages that come with it. And then you have to think, well, okay, if they sign an indemnification clause, and all licensing agreements have them, right? It's very standard, and, you know, I wouldn't agree to one. I would tell my client, you know, don't do this if you can't get reps and warranties. Can they indemnify you, right? Now, if it's A24, the answer is yes, right? But if it's, you know, John from the bodega, or from the 7-Eleven, you know, that I just met, maybe not, right? And so you have to do your due diligence there.
Thank you so much.
Yeah, but us or any one of those amazing lawyers that I referred you to earlier could help you think through that.
We will absolutely be keeping all of you in mind. Thank you so much.
So I think as our event comes to a close, if you'd like to save the chat, you can do so by clicking on the 3 dots on the right hand of the chat box. And I've added the link to the UCI Law Clinic, just so you.
Oh yeah, and there was a question from Nathan Arellano.
Oh, sorry, go for it.
Arellano, is that how I would say it? If there are logos in a gym or on branded clothing within a fiction narrative short film, would that open the film to liability? So not if the logos are being used in a way that that kind of comports with how they're used in the world, right? So Gold's Gym, if you're filming and it says Gold's Gym, you're not violating their trademark. You know, the point of trademark is to protect consumers and indicate the source of goods. So, you know, if someone's weightlifting with, you know, blah, blah, blah weights, then that's fine. They have a Nike logo on their gear. That's fine. The reason that reality TV shows and other shows blur that stuff out is 2 reasons. One, they have lawyers that are just ridiculously conservative and just think that all IP has to be licensed and paid for, and that's simply not true. And the other reason is because they have product placements and they don't want anybody else, you know, who's not paying for product placement to have their logo featured in that production. So just having products in the production should not generally open you up to liability. Now, obviously, if you show someone drinking a Coca-Cola and then falling over dead, you've got an issue. If you show a bunch of super racy stuff, you know, a bunch of drug dealing and violence and you know, indecent or whatever you might want to call it, adult content next to the product, that could be the Coca-Cola bottle, that could be an issue as well. But leaving those out, just showing the world as it exists is okay. That is different, by the way, though. You know, if you stage a set, you know, you want to talk to stage production people who know how to stage the set, so that you don't have copyrighted artwork on the set that then the painters or whoever can come after you for. And there's a really nasty case from like 20 years ago that's still hanging over our heads called Ringgold, where an episode of Rock used a tapestry that was copyrighted, and it was considered not fair use. So if you're staging a set, be careful. But if you're just, you know, using products, those aren't that's not really a copyright issue, and it shouldn't be a trademark issue. So.
Well, what an outstanding presentation. Thank you profoundly, like just so much, Jack, for Professor Lerner. It's visionaries like you and your STEAM clinic that paved the way for the legal creation of independent films. And I cannot thank you or your clinic enough. And we just really express our deepest gratitude for your invaluable guidance during tonight and just in general, like with my production. Without your insightful expertise, knowledge, and heartfelt dedication to uplifting emerging talents, these projects just would not have, they wouldn't come to fruition. They would just remain a mere dream. So thank you from the heart, and what you contribute to all of us is really, it's special, because the world's kind of messed up right now, and there's having people like you and your extensive support and your friendship and mentorship you have generously extended to, like I said, myself and to women in film San Francisco Bay Area is just really significant. And that impact that you have, it helps us to keep dreaming. So thank you, Mr. Jack Lerner, Professor Lerner.
You were very kind. I really appreciate you saying those things, and it's truly an honor. This is a great organization, and if I can be of help, please let me know.
Thank you so much. Now I'd like to give it over to our Vice President, Diane Walsh, to tell us a little bit about our upcoming events here at Women in Film San Francisco Bay Area.
Thanks, Julie. I'd like to tell you about 2 events that are coming up on the horizon. February 7th at 3:30 Pacific time, we're joining New York Women in Film and Television for a virtual one-on-one member networking event. It's not the kind of groups that you've probably been in, and kind of these kind of rooms where there's 10 people in a room. They arrange it so that you're talking to one person, and then you move for 5 minutes later, you go and talk to another person. It's really a really fascinating and an ability to get close to one person and find out about them. So this is a way to meet East Coast filmmakers and even find someone you could collaborate with on a new project. It is for members. We're doing a share here with members. So if this interests you, you can always click on the link for WISPA membership. And I think it's in the chat. Julie, if you could put that in the chat. We'd love to have you join us. We're also going to be having in March a virtual conversation with Lois Vossen, executive producer of Independent Lens on PBS. That's in March 15th at 11 a.m. It's an event that it's a must attend if you're passionate about the art of documentary filmmaking and the power of storytelling. So keep an eye out on our social media platforms and with chat for registration info. It'll be coming your way. And that's it for now. I'll give it back to Julie.
Great. So thank you so much, Diane. We really appreciate it. As our events come to a close, if you would like to, like I said before, save the chat, go for it there. And I just want to thank you all so much for coming tonight. You know, we're all trying to navigate this world of filmmaking as it's changing overnight. It changes constantly and evolves. And so it's really hard to hold on and to keep dreaming these big dreams. So thank you for supporting Women in Film, San Francisco Bay Area. We truly appreciate our community. Thank you to our board members for bringing this event to fruition, and for our tech support, Julie, Genhoi Yang. And you can just see us again next month at our wonderful event, and have a wonderful evening. Thanks, everybody. Good night.